Um, thanks everybody for attending, for participating, and for listening in. We'll have plenty of time, I hope, for Q&A after the initial part of our conversation. So this is all about David McGowan's article in Bipartisan Case Against New York Times v. Sullivan. And it's part of a broader thing we try to do with our new Journal of Free Speech Law, which is to set up these little kind of workshops to help make the articles better, but also promote the articles to a wider range of people, both those who are listening in right now, and we'll also be placing the recording online for asynchronous viewing. So the article will be coming on in just a few weeks. We have a very quick publication schedule, but maybe something interesting will come up, which will require a little bit of tinkering here or there, or maybe not. In any case, what's going to happen is David is going to chat briefly to us about what the article is about. And many of you, certainly all of us here on the panel, but many of the rest of you may have read it already as well. And then we'll have a brief conversation among us, and then we'll be bringing in questions from the chat. Just the other panelists, Ronelle Anderson-Jones, who's at Utah, and she is a First Amendment scholar. Greg Leslie and Dale Cohen are also First Amendment professors, more on the clinical side, and very experienced media lawyers as well. I do a little bit of media lawyering on the appellate level, but vastly less than they. And of course, I write about First Amendment law too. And we're all very interested in this subject, as I think everybody should be. So David, take it away.
Thank you, Eugene, for putting this together and for founding the journal, which is a breath of fresh air in the otherwise somewhat stale environment of legal academe publishing. I'm going to advance 2 points. One is that there are intrinsic flaws in the reasoning of Times against Sullivan, and the second is that it has had a pernicious effect on the development of doctrine. I take the core of the reasoning of Times and Sullivan to be a basic rational actor premise that there's an inverse relationship between the stringency of liability and the production of expression. So in addition to grappling with a genuinely horrible set of trial court facts, the court essentially took some language from defenses at common law defamation, which is actual malice, and imported it in a modified form to the plaintiff's burden. Common law, you're going to think about it as an array of possible choices, a menu of stringency. Strict liability would be the most stringent, and the court seemed to think that strict liability would cause producers of expression to self-censor and constrain their expression. One level down from strict liability would be negligence, and presumably that would mean that there would be expert witnesses establishing a standard of care. The plaintiff would need to prove that the publisher deviated from the standard of care in addition to proving falsity and defamatory content. The court, somewhat imprecisely, but I think clearly over time, opted for recklessness rather than negligence. In a lot of cases, there probably won't be a huge difference between how those cases are tried, because if you go to trial, any defendant is going to tell the same story. They will say what they said was true. If they can't say it was all true, they will say it's substantially true. They will try to demonstrate care to show that they're reliable people whom jurors should believe. And only at the end of the day would they get to saying, and I didn't know that it was false. So I take the principal difference between negligence and recklessness to be negligence allowing the plaintiff to prove a deviation from a standard of care and to prove only the absence of reasonable grounds to believe that something was true, whereas recklessness would require proof that, in essence, the defendant saw red flags, questioning the veracity of a report, and was indifferent to those red flags. The most lenient level would be knowledge, proof of actual knowledge of falsity. But because knowledge here, as elsewhere in the law, could be inferred from circumstance, there are going to be blurry boundaries at each of these scienter-based junctions. Negligence and recklessness might be separable in the sense that if the standard of care required that an anonymous source be verified, so that you had two sources or that you interviewed other witnesses, that would be a provable fact. You either did or didn't. Recklessness is a little bit more inside the head of the speaker, knowledge even more so. That hypothesis that production is inversely related to stringency assumes a lot. And if you're doing an economic model, a serious economic model, you need to think about price. You need to think about elasticity of demand. You need to think about the degree of risk aversion of publishers. The most famous stories in which the press is upheld as the bastion of democracy all tend to involve publishers willing to take great risks. But if you set that aside, what my piece focuses on is an assumption that is implicit in the case, which is that there is a low elasticity of supply, meaning in economic terms, publishers generally have the same risk aversion, they generally have similar costs, and they will generally retract expression in similar ways, and nobody will step in to fill the gap. On its own, I think there are reasons to question that logic. By way of example, if you had sent that case back to the jury in Alabama, I don't think you would have had any trouble getting 12 jurors to come back with a finding of recklessness or indeed knowledge. The problem wasn't the level of scienter required. The problem was that the proceedings as a whole were a misuse of common law. The level of scienter didn't really solve that, but solved that was the de novo review and a straight out adjudication that the case was not actionable. If you look at standards published by the Washington Post, the New York Times, Society of Professional Journalists, I take it as a given, and I would be interested in Greg and Dale and Ronell, your take on this. The publishers you think of as benchmarks, LA Times, Wall Street Journal, New York Times, they would not say that they are ever consciously publishing something for which ordinary care has not been taken. So if we think of standards of liability as concentric circles, they would never knowingly publish within recklessness. They would always say that we take ordinary care. And that's our policy. If we don't have a reasonable basis to believe something is true, then we don't publish it. If that is correct, then the hypothesis of Sullivan that you get an increment of expression going from negligence to recklessness is probably incorrect. However, and this is the point that I make that Justice Gorsuch made and Berisha and Dave Logan made, technology has made even less realistic than it was at the time the assumption that there is low elasticity of supply, particularly with respect to distribution of information. So put simply, a modern day Daniel Ellsberg doesn't need the high fixed cost of the New York Times to get the Pentagon Papers out. His issue would be anonymity. There are a lot of ways to get a direct connection to the public. And then the question becomes, what about republication liability? The doctrinal point I want to make, and the reason that I call this a bipartisan case, is that one of the very few things the left and right seem to be able to agree on at this particular point in time is that they both hate big tech for very different reasons. And although they use very different examples, they both think falsity in public discourse is a problem. I happen to agree with that. And I take Sullivan's corrupting influence on doctrine to be the premise, as Justice Powell said in Gertz, that the First Amendment requires that some false speech be protected to protect speech that matters. Implicit in that proposition is the claim that falsity itself is not a threat to speech that quote unquote matters. I don't think that's true. I don't think it was true when the case came down. I don't think it's true now. What that premise did was lead to cases like Alvarez, in which the court looks at a deliberate lie and says, well, gosh, we can tack together all of these snippets from all these free speech cases, and we're just not sure that there isn't a less restrictive means of disproving this lie, and we plot for counter speech. I don't think there's a strong reason to believe that counter speech works. Cass Sunstein has written very eloquently on this. So that, setting that aside, the point of Alvarez, and I do think this is the fault of Times and Sullivan, is that harms from falsity may be too diffuse to be cognizable. That's a very dangerous proposition. It is not that we cannot discern true from false speech. We do that in fraud all the time. And all of the boundary problems that people use to justify Times and Sullivan are actually doctrine. They're just doctrine and conventional tort cases where there are transactions and more obvious reliance. So I think of that as a problem and a fork in the road that doctrine should not have taken, most evident in Alvarez, but I do think the root is Sullivan. Lots to talk about. I'd love to hear your folks' thoughts, especially where you think I've got it wrong. But that's the gist.
All right. So we're a smallish group. So why don't people just chime in and we'll have a conversation. And if need be, we can use hand raising, but I don't think we need that in a group this size and this friendliness.
I'll kick us off. I have a sort of core foundational question that might be sort of a good beginning question before we get into the weeds on some of the doctrinal questions. I guess I have a question about sort of a core piece of your thesis. Correct me if what I think of as a core piece of your thesis isn't correct, but it seems to me like a core piece of the thesis seems to suggest that Sullivan is problematic because free speech theory and doctrine ought to be concerned with public discourse more broadly and not with the economic welfare of individual firms. And so because in your view, Sullivan was driven primarily by this concept that individual firms had to be protected because they sustained public discourse, it sort of got the calculus wrong and has continued to get the calculus wrong in ways that have become maybe even less true in the changing media landscape. And I guess part of what I'm wondering is, if this were true of Sullivan, right, that it was a sort of economic welfare of individual firms case and not a concern for public discourse case, then sort of why did the unanimous court constitutionalize libel with a plaintiff-based doctrine rather than a defendant-based one, right? The rule rises and falls not on the existence of a media defendant, but on the existence of a public official plaintiff, and right is applicable whether that official wants to sue the New York Times or the citizen journalist or the pajama blogger or the random person on the street who criticized him. So I guess sort of like, what's the explanation for why a court that was motivated solely or primarily by the principles that you attribute to it would select sort of what would seem in that light as a sort of very roundabout mechanism for achieving those principles?
I don't know that it was specifically the New York Times. I think it was a class of firms. But given the technology at the time, that's understandable because that's the firms, and in particular in that context, it was national media firms that would be doing regional coverage of the South and not be dominated by Southern interests. And that's the very specific, this is why I think it's right that it's more of a civil rights case than actually a free speech case. Why you would import it into the elements of the claim rather than the defenses is the same reason you do it in HEPS, which is it is more protective. So, and it's not just individual defendants, that one of the tells in Sullivan about how bad it was in the trial court is there should have been a J-Mall on the 4 individuals. As far as I can tell, there was no evidence in the record that any of the individual defendants approved the ad. They're held liable nonetheless. So it's not just the Times, but I think that was incidental for everyone. It was really an effort to choke off those substantial firms. The expansion of the doctrine you're talking about did happen over time. And typically, given the technology at the time of the expansion, those were things that were reproduced through firms with high fixed cost and high footprints because ordinary people didn't have access to distribution. So what's changed, and the reason I think that people are misconceived to be focusing on 230 as opposed to Sullivan, is that 230 is about distribution. And if you're worried about falsity, you should be worried about creation first. Do I think Hugo Black consciously sat down and thought, what can I do to raise the New York Times margins? No. Do I think he thought they will stop covering the South if they get hit like this every time they publish? Yes.
David, I have a similar kinds of question about your foundational principle. When I read your piece, and I also went back and read Professor Logan's piece, which you cited back to frequently, it seemed to me that you're both talking about a problem, a price that's being paid because of the actual malice rule, and it seems to be tied to the misinformation or disinformation problem, fake news that we all agree is in fact a real problem. But when I think about this and when I read your papers, it seems like the three primary sources of that misinformation are foreign and hostile powers, political leaders and political candidates, and I don't just mean people running for office, but people who are pushing social issues, and these kind of shadowy sources on the web, call them anonymous trolls, sock puppets, whatever term we might use. And I have difficulty understanding how reversing the actual malice rule is going to impact any of those three groups, or how it's going to make the fake news disinformation problem any better.
I don't know that I agree with the premise. So I don't know. The most interesting things going on to me right now in this space are the Dominion voting cases.
Okay.
I don't know which category you would put those in, but these are cases brought by Dominion and by Eric Coomer against sort of a host of people.
Okay.
Some of them are established media firms, Vox. Some of them are, I would say, a tier down, podcasters, but people who were nationally syndicated at one time.
Okay.
Some of them are people who are individuals who previously, under vintage 1964 technology, would never have had a platform. That's what Eugene years and years ago referred to as cheap speech. I call it the democratization of distribution. So I don't think those are not foreign powers. They're not political leaders. I don't know if they're shadowy sources or not. There is no longer a bottleneck in distribution. So who a source is, who is a political leader, is to me a function of how many people follow them.
Well, I guess I guess we do disagree, because I think that at least two of those three, and maybe all three of those categories, fit those cases that are being brought by Spartmatic and Dominion. But just tied to that, I mean, those lawsuits are out there, all right, and they haven't been dismissed. They haven't been thrown out because of actual malice. There's plenty of evidence that certainly in recent years, that the law of libel is not dead. I mean, I can recount, a dozen off the top of my head cases where libel plaintiffs have succeeded despite the actual malice rule, despite New York Times versus Sullivan, starting with the beef products case, where a settlement that's been reported as being roughly $200 million was reached in that case. Nicole,
177. Yeah.
I'm sorry?
177.
Well, okay.
Yeah,
I
it's a lot of money.
Quibble about that. I think that's only partially what's been reported, and that's not the insurance proceeds. The Aramo case, the University of Virginia against Rolling Stone, she wins her case despite the actual malice rule. Sarah Palin's going to trial against the New York Times. Nicholas Sandmann won a series of settlements because of the stories about him and his Covington Catholic friends. I mean, again, I could go on, and certainly the actual malice rule hasn't stopped Donald Trump and Devin Nunes and others from filing lawsuits that probably are not about winning money or repairing their reputation, are probably about deterrence and efforts to punish or take retribution against people who dislike them. So I'm just having a difficult time identifying what the problem you're really trying to address in reversing the actual malice rule is.
So I don't think that, if I can distill what you just said, I think it is true it does not bar the filing of all suits. The Coomer cases now are in anti-SLAPP stage, which is a predictable stage of any case like this in a state that has an anti-SLAPP rule. We'll see where they land, but because the second step of an anti-SLAPP motion is probability of prevailing, the scienter level is irrelevant. But if the claim is actual malice rule does not stop all cases from being filed, I agree with you. I don't know what follows from that. It doesn't follow that it's a good rule unless some cases can get through as the criteria. The increment that it posits over negligence, which is kind of where I like to land, because negligence is our typical way of equilibrating investment and precaution relative to risk, is it okay for somebody who does not exercise even ordinary care to publish a false statement tarnishing someone's image just because they saw no reason to believe it was false, even though they also had no reason to believe it was true? And the question is, why is that a good thing? And when you read the briefing in some of these cases, I do think that's where it lands. If I can prove I didn't see a red flag and just ignore it, under the actual malice rule, I win. I may have taken no precaution at all. That to me is symptomatic of what I think of as the Sullivan opinion's overly sanguine view of falsity in public discourse. And it's interesting. Fred Schauer did this years ago in his Nimmer lecture. The First Amendment has all of these wonderful doctrines, and it's got more slogans than you could cover a bus with. And then on the topic of falsity, everyone just sort of goes, ugh, yeah, wow. Yeah, falsity is bad, and then you see these, Orwell gets trotted out so fast it makes your head spin, which is, a terrible misuse of him. But I don't think the fact that a case can get filed actually says very much. The question is, as a policy matter, what level of precaution do you want to have as your trigger for liability, given that falsity now is an element? And this is why I say I don't think the traditional media, I don't think they would ever say that they knowingly take advantage of recklessness as a standard. They always use at least ordinary care. And if that's the case, then at that level, all this doctrine does is express a fear of juries. Because presumably the Wall Street Journal knows what the standard of care is for news reporting. They said it in a lot of cases. So maybe a jury thinks the standard of care is something that it's not. Maybe they buy an expert and they shouldn't. Or maybe the jury disbelieves a witness and thinks, even if we got the standard of care right, we incorrectly think that you deviated from it. Those are the options. I don't think anyone thinks realistically that we should scale off the Sullivan jury as representative of juries generally, because if you really believe that, you would just shut down juries. And this would always be a question of law, because that case was so bad in so many ways. It is a little bit awkward to say that juries can assess design defects. They can judge whether a patent claims a novel genus of a chemical compound. They can decide whether a doctor used an ordinary care in a surgery. But when it comes to looking into the mind of a reporter, they're just really untrustworthy.
But is speech not different, David?
Is speech not different? It's non-rivalrous. If by that you mean aren't all externalities from speech positive, the answer to that is no.
That's not what I meant. But
isn't that the very purpose of constitutionalizing the tort, to say that because of the value of expression, maybe it can't be entrusted to the same level to juries as a lot of other legal matters. And I came to this article from a different perspective. Like you've stressed right from the top that this is all about big media. My practice when I was legal defense director at the Reporters Committee for Freedom of the Press was always coming at it from the small guy, the small speaker, who, if they said something wrong, could suddenly have to be paying $20,000, even just to hopefully fight under an anti-SLAPP statute or a motion to dismiss. And that alone could be devastating to their entire operation. So, I guess I came at this from a different perspective. Like, we need this constitutionalization, which is best expressed through an actual malice standard, to have little speakers survive at all. And that's even pre-internet, the freelance author, the book author, the lonely pamphleteer.
So, and Dale, I don't mean to be flip by saying, does it mean all externalities are positive? I'd like to focus, if people think that speech is different from a jury point of view, on why that might be. Greg, anti-slaps have mandatory fee provisions. So if you win, I mean, you're going to get netted up there. I do think the focus in Sullivan was on this dynamic. Hugo Black's an Alabaman, of Northern media being the ones who are willing to go down and do reporting that the Southern papers aren't going to cover because they're owned by the people that are being covered. So I do think it was focused on that idea. So if you take a step back, it is obvious that the domain of the First Amendment cannot be words. We trust juries to assess fraud cases, negligent misrep cases. We trust them to do scienter and Ponzi scheme cases, securities fraud cases, all of that. So it can't be that it's words, because juries get words all the time. Promissory estoppel, breach of contract, Cohen and Cowles media. It's not that it's words. So, and this is why I came to this, because I was a research assistant for a professor a long time ago who focused on the sociology of relationships as the key to understanding First Amendment issues, and why people have so much trouble with falsity, because everybody knows falsity has to be punishable without First Amendment scrutiny. And negligence has to be punishable without First Amendment scrutiny. That's legal and medical malpractice. But at the same time, they get very worried if it's published to a large number of people and therefore can have greater effects. The small firm either acts carefully or it doesn't. Do I tie actual malice to market cap? Do I tie actual malice to profitability? Do I tie actual malice to margins? That doesn't seem to me adding it into an accounting exercise helps. If the idea is that the small firm might not be able to meet a standard of care because they don't have the resources to do it, that's inherently a problem. And that's a problem in the modern era too, with small speakers who might not have a lot of resources, but now have widespread distribution. So the doctrine's not tied to those folks. Because you're small, does that mean you would necessarily cause small harm? I don't think that's right. I like a lot of the things that sprung up out of Sullivan that aren't scienter-based, but things like having a rule that requires damages to be tied to proof, which is the rule elsewhere in the law. All that does is flip the presumption that you used to get in defamation off of libel per se. You know, de novo review, but at the end of the day, if a small press defames somebody and lacks ordinary care, have they contributed positively to public discourse? No. They said something that was untrue. Do I need to give them a break so that they can say other things that might contribute to public discourse? And that's what I refer to as the elasticity of supply. And the thing that, and I think Renelle put her finger on this when I did the antitrust reference in the paper, from the marketplace of ideas point of view, it's important that things be said. It's not as important who says them. So if the evening newspaper in a city goes under, like a lot of them did, and we had an antitrust exemption to allow those to be merged, does it follow that public discourse in that city is impoverished? It does not.
Yeah, so Dave, can I just piggyback on the idea that Greg was, maybe just by recharacterizing it and adding to it? I guess a piece of the question that Greg's question spurs for me is sort of how, if at all, we in your sort of economic analysis framework are taking into account the possibilities of like the need for breathing space or the self-censorship possibilities for like the new non-institutional press. So if the argument here is focused on a new communications landscape in which the variable costs of expression are negligible and the fixed costs are being incurred without regard to public discourse. And the central notion is that there's this serious weakening of the premise that the organized press needs economic protection from defamation suits in order to sustain that vibrant political discourse. Then where are we calculating the ways that defamation threats can equally be used as a cudgel against non-press defendants. The guy on his lone soapbox or the random person with cell phone footage, they also have a need of economic protection from defamation suit if public discourse is to be vibrant and public officials are to be held to account. Like the deep pockets argument, I understand, but public officials, as Dale says, are suing or threatening to sue for defamation, not exclusively about recovery, right? It's about silencing, which means that deep pockets might cut in two ways. I think that's sort of what Greg's getting at. People with limited means may well be quite easily silenced. If, you know, a culture of fear and pervasive defamation actions by the powerful against their critics becomes really constitutionally permissible, right? Sort of how is this changed communications landscape really changing things? I guess, like, put another way, how does the new landscape undercut the premise about economic protection being key to vibrant conversations on matters of public concern if it just like replaces one set of chilled speakers with another? And probably, I guess, and a concomitant question to this is why, given the nature of the desire to sort of silence or punish critics, why would we necessarily assume, which I think your paper probably assumes, like differential probabilities of suit based on the defendant's wealth?
And I said that, I think, at the end of this paper. I've got a paper on SSRN called The Internet and the Limping Truth, which is a Jonathan Swift quote. I go into it in more detail there. So the question is, can big, rich plaintiffs
powerful, which are sometimes the same thing, but not always.
Sure, I don't know. So Devin Nunes may not be rich. If I can take that as an example. In my, this will betray my political biases to some extent. The only social media I follow is Devin Nunes's cow, which I find just the most wonderful thing ever invented. Although my T-shirt is ripping apart. So how does the actual malice rule solve this problem? The actual malice rule does not save you from the filing of the suit, which was Dale's point. It may give you the promise of recovering fees when you file your anti-SLAPP motion, if you can find a lawyer to take you through that motion. True. And if you are incautious at a level where a judge says, wow, you really just kind of didn't look at that and think it through, might you have to go forward? Yes, you might. Nothing short of flat immunity solves that problem. All of that presumes that the other elements are met, which includes that you said something that was false. So I think a lot of the, to frame it in a way that is favorable to my thesis, you would say, a lot of people just don't seem to believe that falsity should be chilled. And falsity should be chilled.
So, David, I wanted to ask you a question that's related to all of this, and it takes us back to the jury, because it's true, if the jury was our perfect determiner of negligence, we may feel more comfortable with leaving such questions to it. And in fact, it may not need to be perfect. It may just need to be good enough, and we seem to think that it's good enough in various other areas. Here's what I take it as one possible concern. This relates to what I think of as the Rita Hayworth problem. So supposedly Orson Welles, who I think was married to Rita Hayworth at the time, on some movie set, somebody remarked that she was sweating, and he said, "Horses sweat, people perspire, Miss Hayworth glows." Right. And this is it's funny, it's chivalrous. We want spouses to speak up in favor of their spouses, but it reflects a facet of human nature, which is that how we evaluate things said about people depends a lot on how we think about those people. So one way of thinking about New York Times v. Sullivan, focused on public officials, is that even in situations where there isn't the kind of very intense feeling that arose in the South among white juries with regard to, at least many white jurors with regard to civil rights movement. Still, when you see there's something that was an error, in some measure material, how much we don't know, but potentially was an error, and where it's quite clear that the newspaper wasn't lying, there's no evidence that the newspaper was lying, and the question is whether they acted unreasonably. The human nature is to say, people on your team, well, you know, mistakes happen. Whereas people on another team, this is a total lack of any journalistic standards whatsoever, right? That's human nature. Maybe a little bit less so if you are dealing with a standard private concern libel, like some employer supposedly gave a bad review to reference to an ex-employee. Maybe even with regard to private figures on matters of public concern. But when you're talking about public official, where a person, the juror will often have either voted for this very person or against this very person, not always, but often, that maybe we do think that this is an area where the decision is going to be more influenced, precisely because it's such a vague and subjective question, what is negligence and what is not, will be more influenced by political prejudice, at least more often than by any real application of consistent standards. So I wanted to ask you about that, and then I thought we'd be time to do it for Q&A.
Yeah, and and it might be, it's interesting. I don't know if that intersects with Vernell's point about big wealthy versus defendants versus not wealthy defendants. So juror bias, if it's a politician, might jurors be biased? I think the answer to that question is it's possible. That's why you do voir dire. It again, I think, argues for immunity, which is kind of where Harry Calvin wanted to go, because a biased juror, and it was a biased juror likely to say, well, objectively it was negligent and it is false, but I don't think they saw any red flags. I mean, if you're going to try one of these cases on the plaintiff's side, what you have on your side is that you can prove falsity. If you can't prove that, you're going to lose.
Right.
If you deserve to be in this line of business, it will be easy to find 4 or 5 facts that, with the help of hindsight bias, you can call red flags. And if recklessness, if I'm right that recklessness is sort of a red flag rule, there were red flags there and you ignored them, then this is why I say the boundary can get fuzzy. I think that is true for an unbiased juror. I think it's true for a biased juror. I agree with you about that. Is the risk too high? I think it's an interesting question. I think that's one of the reasons you have de novo review, which I think of, and I disagree with Dave Logan a little bit on this, which I think is vital to keep. But at the end of the day, there's only one way to eliminate that. And I don't know that the margins between these levels of scienter have the importance that get placed on them. I pick on them because I think they are animated by an indifference to harm from falsity that is unrealistic, as exemplified in the Gertz quote. But if you ask me, is it, if the jury, a biased jury, is nevertheless following its instructions scrupulously and setting its bias aside, then it is possible that a biased jury could say, you didn't use ordinary care, but I don't really care about that because the judge told me that it's not enough for you to have blown by ordinary care. You have to ignore the red flag, and I don't see a red flag. I think that is possible. What fraction of cases that would happen, and I couldn't say.
Got it. So Larissa Linsky, for the benefit of those of us who don't realize there's only one Larissa in this space.
Like Madonna or Beyonce.
Exactly, that we need to listen to, and ask several questions. Let me ask them one at a time, and also I'm encouraging others to ask questions as well. So first, because my wife is an insurance lawyer, and I've absorbed this issue as well, is how does the existence of insurance affect the regime you recommend?
So insurance is going to be priced relative to expected cost. So I would expect the cost of defamation insurance to go up somewhat. I'm not sure how much it would go up, and I don't know that we would have state-to-state data. You might look at policy differentials from pre-64 because there was a fair degree of heterogeneity among states in that time with respect to defenses. I don't know, and this goes to a second question I see, which is, what's the standard of care for a podcaster? That's a really interesting question. And a lot of the back and forth in the Coomer papers, and if any students ever watch this, these are up on the County of Denver website, and I don't think law school does enough by way of giving students original trial court materials. It's wonderful to see the debate going back and forth at the level of declarations and depots. Who's a journalist? Well, if you say you're a journalist and people read you, are you not a journalist? I'm inclined to think that you're going to have the same standard of care for somebody who's got a podcast as for anybody else. That's going to be a fact question the same way a person of skill in the art is a fact question. It's going to be, whom do you believe the standard of care is? And if somebody says, well, look, I'm just a person. I happened to listen into this meeting and I heard a statement and I'm going to tell the world about it. And it's unfair to hold me to a standard of care. I'm not a fancy journalist. That could be a position someone might take. That's going to be a fact question. And we don't have an answer to that right now, I don't think, because most of the cases I can think of involve people making statements that are picked up and retransmitted through broader means. But I can't think of a reason why it would be any different than, say, a negligent misrepresentation claim in a private transactional context. The question is the same. Did you have an adequate basis for the representation you made? But what is an adequate basis?
If I can just probe a little further, I take it part of the issue is that we would presumably expect something different from somebody who has the resources of the New York Times versus somebody who is trying hard. Let's say it isn't Alex Jones, where people sort of suspect that he deliberately may be shading, maybe cutting corners to get things that are as dramatic as possible. Somebody's trying hard, but who's taking advantage of the opportunity that the new technology gives for an individual to do things, right? And we do, generally speaking, say that the standards of care, I think, are different for somebody who's, let's say, the claim is, I own a small store and somebody, let's say, is injured through some not uncommon accident. Whereas if this were Walmart, then maybe they could have much more comprehensive mechanisms of dealing with this. Or likewise, in the absence of a Good Samaritan rule, as I understand it, if I'm trying my best to save someone's life, even in the absence of a Good Samaritan rule, the fact that I didn't realize that this isn't the right way of doing it, I'm not a doctor. Whereas if I were a doctor, then the standard would be higher. So do you agree that there would be different standards, and you just think that that's just a matter of fact to be decided by each jury? Or do you think that it makes sense for there to be developed a kind of a clearer set of rules as to what's consistent with the standard of care and what's not for different kinds of speakers?
Yeah, so the standard of care, I don't know that your Walmart example, I think it depends on what the cause is. If it's a broken glass in the aisle, I don't know that it's all that.
So maybe an example is let's say there's a tornado and somebody is injured, and Walmart might have been able to put up a tornado shelter. Probably it does have tornado shelters. Whereas my little mom and pop shop, doesn't really make much sense for me to require that.
So I think that the doctrinal articulation of the standard of care is going to be that you would act with reasonable prudence as a reasonable person similarly situated would act. Its application is always fact specific. So what you have, and this was the issue in Cohen against Cal's Media on remand, what you have for established journalistic institutions are their own internal codes, more in print than in broadcast, I think. But you can go to the Washington Post website, you can go to the New York Times website, and they will say, these are our ethical standards. And that helps establish, they're not all that specific in terms of fact checking, they're more specific in terms of conflict of interest, which is important. So let's take an example of I, the podcaster, get a report from somebody who is anonymous. And I, at the Washington Post, get a tip from somebody who is anonymous. Does the standard of care require that I follow up and get a second source? Or can I publish based on the word of one person? Typically, it would be, who is that person? How do they know? Do I know how they knew? Is their story coherent? Can the Wall Street Journal get a second source easier than an individual? I don't know the answer to that question. Maybe they call up and say, I'm from the Wall Street Journal, and people are afraid and hang up. Maybe they say, oh my gosh, I've always wanted to be in the Wall Street Journal. What could possibly go wrong? And they talk. I don't know the answer to that question. If it is the case that a second source is required, and it is the case that people are more willing to talk to media outlets they recognize, then it will be easier for the journal to satisfy the standard of care than podcaster. If it is the case that the second source believes the Wall Street Journal is a corrupt tool of capitalist interests, the reverse may be true. You're right, at a certain level, the application of the standard of care, what it requires, is just going to have to be thought about if it's a negligence regime. I don't know that that's bad, but it is possible. And I guess the reason I hesitate on this, and I want to gravitate towards a reasonable foundation for the statement that is made, is that the individuals who have become speakers by virtue of the democratization of distribution are a heterogeneous bunch. I think they're more heterogeneous in their competencies, their inclinations, their training, than are people who work for the Times and the Post. That can cut different ways. They could be highly expert in a field in ways that no reporter would be expected to, and they might report in that field, and they might have the knowledge to say, I can tell true from false in this field because I'm an expert. Presumably, they could make that as part of their argument why they satisfy the standard of care. But I do think it's a fight. It's going to be a fight if you go to a negligence regime, and there is a risk that a jury could say, well, you should have done more, in a case where the person really doesn't think they could have done, because it is conceivable that some articulations of the standard of care are going to be more objective. And did you call two people, or is it just one person? That's a counting exercise. That's going to be relatively more tractable for a jury than what went on inside your head. So I think that's a risk. Remember, you don't get to this until you've proved all the other elements of a hypothesis there has been harm caused by falsity. Otherwise, we're not talking about it in the first place. So then the question is, what's bad about that? And what's bad about that, presumably, is something that might be true will go unexplored because someone is worried that they won't be able to show the standard of care. I suppose, and this would be disappointing, but I suppose what the person could do would be to send it to somebody at the New York Times. That would kind of bum me out because I like the idea that people have I really like the democratization of distribution. That's one way to do it. That's what Daniel Ellsberg did. We've just seen all of these Facebook disclosures. That's a model that's fairly well articulated. So I don't think that it follows that the information will not be disclosed. And from a public discourse point of view, I'm more interested in whether the information is A, disclosed, and B, true, than I'm in the specific identity of the person disclosing it. Put slightly differently, a lot of reporting, I assume, is based on tips. It's based on reporters calling people up and getting them to say things they probably shouldn't say, And that's what I do in the morning. I call people up and see if I can get them to violate their NDAs.
It's sort of an interesting question whether that is actionably tortious. Oddly enough, not a settled question either as a matter of tort law or First Amendment law.
And if you take a look at the California Rules of Professional Conduct amended in 2018, you will see a very strange change applying to lawyers doing that. Traditionally, the division there in tort law, I would think, would be between statutory violations and violations of contract rights. So you could get a third-party witness to tell you something in violation of an NDA, and that would not create liability for an attorney.
Mm-hmm.
You can't get privileged information or work product information. Those are legal prohibitions. It is a fair question. And I think most people assume that reporters, A, won't have to disclose the source, so it'll never come out whether there's an NDA, or B, would have First Amendment immunity for the tortious interference claim. I am not aware that that is settled either.
Right. So much is that you think would be.
Dave, can I ask you a question about just sort of just connect the dots for us on the position that you take on what I think you label corollary doctrines, right? The the non-actual malice consequences of the progeny of Sullivan. So, burden of proving falsity, the damages rules, de novo review, which I think of and sort of teach to my media law and First Amendment students as kind of branches in a traceable family tree that began with Sullivan, right? Sort of Heps as an outgrowth of Sullivan, Gertz, all sort of offshoots of the Sullivan reasoning, building on a framework. And I guess, I guess I have a couple of, a cluster of questions related to that. Am I reading right that you want all of those to continue on despite the unwinding of the sort of beginning, the actual malice premise of Sullivan? And I guess then the question is sort of, why specifically should they survive if the root of them is cut away? Or do you not think of that piece of Sullivan as being in any way connected to the development of that, the additional jurisprudence?
I completely agree with you. There are branches from that tree. They do not display what I think of as insufficient sensitivity to the harm of falsity. So just by way of example, the New York Bar, I mentioned this to you guys earlier, the New York Bar just gave an interim suspension to Rudolph Giuliani, based in part on statements made on a radio show, his own radio show, in which at least the disciplinary committee report says, he said there were 2.5 million absentee ballots returned in Pennsylvania and only 1.8 million came out, were sent out. And if that were true, if you hear that statistic, you go, wow, that ain't right. And at least according to the disciplinary action, that was a mistake. It wasn't 1.8, it was 3 million, right? Take an example like that, obviously a statement of fact, but not of and concerning a specific person. Can a statement about, extrapolating away from absentee ballots, just anything to do with elections, can a statement about elections, not of and concerning a person, but which is false, erode confidence in elections? I think the answer to that is yes. I think that's outside the domain of Sullivan, because it's not of and concerning a person. I think Alvarez, which is the source you would cite to say that that's not an actionable statement, is a product of Sullivan in a way that Heps, making falsity part of the plaintiff's burden, de novo review, which is implicit, I mean, it's in Sullivan, it gets ensconced later on. Those aren't. Those are really checks on, is what happened in the trial court something that's going off the rails? Is it suspicious? Do we think there was, to take Eugene's example, partisan sentiment swamping the record? De novo review isn't a perfect guarantee of that, but it's going to be one step up. In a diversity case, it'll be in a circuit court. It's true that a lot of these cases are going to be state court, but you won't be in the exact town. You'll be in the same jurisdiction. I don't think of those as having the same corrupting effects. You say they're branches from the tree. if I go back to what I said in terms of, if you remanded that case on a recklessness standard, what do you think happens on retrial? I'm going to vote for the same outcome. Okay. If that's true, it follows that the actual holding of Sullivan in the case, actual malice is dicta. What really drives that case is the court's willingness to say, and you're not getting it back, we're doing this up here. Now, it's not dicta because it's the premise of the case, but it's not really what drives it. So I agree that it's the thing that it's cited for is that holding. The thing that I think of it as being driving the result is that they weren't going to send it back because they were going to claim the ability to do this on appeal with a de novo look. And I think that's tremendously important as a check. So I don't think they suffer from the things about the actual malice rule that bother me, which is this, I think of it as skewed. And Dale, I was saying earlier, are all externalities from speech positive? I don't mean to say that you're suggesting that. A lot of this debate, certainly the debate in Alvarez, a lot of free speech debates seem to proceed as though there's potential upside, and the downside is just something that's not weighable, it's probably speculative, and it can be fixed through counter speech. And so it just gets swept away and it's not paid serious attention to. I think that's a mistake. And I think that mistake traces back to that move in Sullivan.
I'm not sure I understand how the line from Sullivan to Alvarez is being drawn, but I'm not sure I agree with how you're characterizing Alvarez in any event, because I don't think Alvarez says false speech prevails over everything. I think it said false speech is speech, and as in all of the First Amendment cases, what the court has demanded, not just the current court, but throughout history, that there be precision in regulation and that there be compelling governmental interests and narrowly tailored solutions that are selected. And in Alvarez, the government did not demonstrate that there was a governmental interest that was being narrowly attacked with the law. But there's been no challenge to the way Congress changed that law once they got that decision from the Supreme Court. But I really don't see how Sullivan leads to Alvarez, because Justice Brennan very clearly said intentional falsity does not have the same kind of protection that you're suggesting either the Alvarez court or the Sullivan court said it should.
Yeah, no, so Alvarez exempts from regulation deliberate falsehood.
No.
No, they say it was a lie. It was
certain deliberate falsehood.
What's that?
Certain kinds of deliberate falsehood.
Right.
Yeah, so in that case, the speech at issue in that case, so the holding of Alvarez, if we want to do it very precisely, is that deliberate falsity is not a sufficient condition for regulation.
Okay.
That traces to Sullivan and the citation patterns and the opinions. If you look at Breyer and Kagan, part of their ode to falsity, which includes J.S. Mill, Sullivan is in there. Sullivan is the cleanest doctrinal example of the proposition that falsity must be tolerated in certain circumstances. You're right, actual malice does not extend to deliberate falsehood. It was extended in Alvarez, albeit to that expression. Why did the majority, sorry, it's a plurality opinion, why did most of the justices say that you couldn't regulate? And Larissa says no cognizable harm. That's the argument. And that's my point. So the analogies in Alvarez were to tarnishment and dilution. They were to trademark law. I can't for the life of me understand why that's wrong. I get the justices don't agree with it, but everybody can stand up and lie and say they won the Medal of Honor and the medal as a signifier is not affected by that. If that's true, then speech is so feeble, there's no point in protecting it. That's what I mean by the diffuseness of the harm. The harm is there. They don't care about it because it's diffuse and they think you can come up with alternative means. The don't care about it part is a branch, I think a bad one, from the Gertz premise that some false speech must be tolerated to protect speech that matters, and that is a direct line to Sullivan.
I agree with that, but I think the court was trying to balance all of these interests, and you know, for me personally, and based on my experience, like Greg, like others who have represented these clients and these speakers, I think that the court drew a pretty good balance. And the reason I started with what exactly is the problem with the way the law is working is that I'm having a difficult time finding what problem is solved by overturning the actual malice rule.
Sure. So my view is that it will start to push back against what I think of as a deliberate misweighting of the damage of falsity. The specific topical hook is the elasticity of supply. That's easy for everyone to see. It's fairly clear that this scienter output correlation is at the heart of the logic in Sullivan, and it's fairly clear that elasticity of supply is a problem for that model. I'm much more interested in things like, at what point does generic falsity become cognizable? What do you have to do to say, you know what? And here's the example I sometimes think of. Let's say that using the new technology, I find a jurisdiction in Georgia, and I look and I say, wow, this is a wobbler. And I have the means, because I've acquired through, you know, whatever means, I've got a list of voters from one part or the other. And I send them a note that says, you know what? The polling place on the corner of Main and Walnut is closed, and the new polling place is 5 blocks over. There isn't a new polling place 5 blocks over. That's just a lie.
Well, that might very well be punishable. But
why?
Why? Well, this is the unresolved question following the Breyer-Kagan concurrence, which is big on unresolved questions. By the way, I filed an amicus brief in support of the position that ended up being the dissenting position.
Yeah, I read your brief. I think I cited it.
The generally speaking categorical, generally speaking, lies should be punishable, with possibly an exception for what I might think of as big picture things about history, politics, and the like.
Sure.
But specific details, which are easily verifiable, like whether you won a Medal of Honor or where a particular polling place is a different matter. I think what Breyer and Kagan would say as to something like that is that there is a compelling interest in preventing elections from being swayed by this kind of false statement. And the restriction is so narrow that we are much less likely to, we have much less to worry about than we would if we were talking about categorical prohibition of all false statements about politics in the course of an election campaign. That this is the sort of thing where juries would be especially likely to get it right, the chilling effect would be especially little, and the possible harm to the election would be quite significant. I think deliberately Breyer and Kagan were trying to leave room through this intermediate scrutiny that they were setting forth precisely for this kind of thing. So I don't think the problem is that there's no room for it. It may be that the room is too vague, or maybe there should be room for other things. But for that particular restriction, I think that's sort of what the Breyer opinion is tailor-made for.
I would like to think that, although I didn't posit the language of a regulation. You were saying it's so specific. The example is specific. If we go back,
right. If the regulation were broader and said any knowingly
don't lie. If it was just a regulation that said nobody shall lie, obviously.
Right. Well, yes, then that would be overbroad under Breyer and Kagan's own position. Yeah.
Right. But if it was a specific regulation targeted at cognizable harm, Alvarez leaves open the possibility that remains punishable.
So the voting machines were hooked up to the internet. We were kept 70 feet from the polling place. The election was stolen. Now, these are all going to be ex post. The election of stolen is the broadest of them.
Right. And that's a classic example of the sort of thing that I think that justices should be very hesitant to allow a restriction on, because it is an evaluative judgment of a vast range of factual allegations, which, I don't find persuasive, but it's the kind of thing, it's like whether JFK was shot by a lone gunman or not, right?
And under
It's
Greenbrier, it's
effectively-
going to be it's going to be read as hyperbole, and it's not going to be taken as literally
either
true.
read as hyperbole, or in the very least, it's the sort of thing that you don't want juries to be deciding because it involves an evaluation of so many different things. On the other hand, when the particular polling place closes or where it is, that's a different story. That's the kind of thing that I think one can allow a prohibition of without much worry, at least as to lies, without much worry about partisan jury decision making.
So there's a continuum.
In all of life, there's a continuum.
I know there's all of life a continuum. The reason, when Dale, you say, what's wrong with it?
Mm-hmm.
It's got a thumb pressing up on the scale of falsity. So I've got some discrete statements in there, and we talk about the broadest of them. I'll put the election was stolen out there because that's easy. Everyone's going to say, we don't want to go there. And I agree with you. And Eugene, to me, this is just the ratio of reliance interest to other interests. A very specific statement about your own that's relevant to your own conduct is going to read a lot like deceit. It's the kind of thing that we let people sue over all the time. And it's got a democratic process hook. And I think of this as a ratio, how much of it is about you, how much of it is your own conduct. And I read the reliance interest off of that. You've got the mid-range about all of the allegations that were made about, were these machines hooked up? Were these boxes stuffed? This, that, and the other. It is, and all of those can be framed in very discrete form. So if my proposed regulation punishes false statements about an election, there's a Sixth Circuit case, I think it's Daughters of, it'll come to me in a minute, that says you can't prohibit deliberate lies about a candidate, which is pre-Alvarez, but certainly Alvarez is consistent with that. So can I pass a law that says it is sanctionable deliberately to tell a lie about a candidate? I think post-Alvarez, that's probably not actionable.
But I take it a law that says deliberately tell a defamatory lie about a candidate probably would just be criminal libel.
Sure. I mean, I'm not worried about whether it's prison or a fine or whatever the remedy is. I don't think you could have that law. That to me is an artifact of the difficulty free speech doctrine has with falsity.
But I'm sorry, but a law that bans deliberate lies about candidates, I think would be a deliberate defamatory lies about candidates would be libel law, right?
Yeah.
So if it were a deliberate defamatory lie, yeah, so I suppose the statute I'm thinking of, it was an Ohio statute, and it was enjoined, and it was a knowing standard, which was also
I wonder if you have in mind the Washington statute. No, maybe not.
It's a Sixth Circuit case. It'll come to me in a minute.
I think my vague recollection, I may be wrong, is that the Sixth Circuit case, which actually reversed an earlier Sixth Circuit case, dealt with statements about elections generally. But there was a Washington case that actually, which I think may have been wrong, which actually dealt with false statements about candidates. But it may have been focused on defamation. But in any case, I'm sorry.
No, that's so.
Don't sue me.
No, it's quite all right. However you cash it out, I think people are having a harder time with falsity than they need to. I think the doctrine is having a harder time with falsity than it needs to. And that's because of the premise from Sullivan. So that's, Dale, if you ask, why would it be better? Part of it is that I think it would start to counteract what I think of as a little bit of a snowball effect. And I think the nice thing about the ambiguity in Alvarez is we can all guess about what it would mean in a practical application. And you're right, Eugene, a defamatory statement that was knowing presumably be cashed out in a civil suit later on. Whether it can be enjoined, you get your standard prior restraint stuff.
I have an article on that.
Yes.
The answer is yes.
So that to me is the connection between them. There's a lot of stuff it doesn't touch directly because the domain of the actual malice rule is, you exclude hyperbole, you exclude Falwell, things that are not literal truths. But it's always been a puzzle to me why falsity as such is so hard in the doctrine. And when I look at the chill and I sort of say, how is this going to ground out? Oddly enough, it may well be that at the moment, if it is correct that established media firms are never less than ordinary careful, that the principal beneficiaries are the sort of new media, not platforms, because they're not authors in their capacity as platforms, but the people who have been brought in by the fact that you can now do a podcast and reach 300 million people, in theory. If we think that in general, those folks, the ratio of false to true things that come out of that tranche is really bad, and I don't have a view one way or the other, I just think you look at what they said and you assess it, then that would be a reason to think there's a problem in the system. I don't think that case has been proved yet. But if you think you've got a lot of little speakers who are all there saying, well, nobody's going to sue me because I'm not worth suing, I'll just say whatever I want. And then a layer up, you've got somebody who's got a little bit of reputation saying, well, 5, 10 different people are talking about this. Everyone's talking about it. There's got to be something to it. Where there's smoke, there's fire. And then a level up, it just multiplies. At some point, you get a trial and you get an anti-SLAPP fight where the declarations and the deposition testimony is, look, we checked with 5 different people. They all thought it was okay and they're all up in the chain. And I don't need to do more than that. And it's maybe an echo chamber. So at the very end of this paper, I talk about differentiation. And it's sort of the flip side, Ronell, of where we started, which is if you were trying to differentiate yourself based on reputation for truthfulness, you might like more stringent liability standards. Because you could say, we could meet them, and these folks who aren't willing to step up and do fact checking, our relative voice will be greater, which is a way of saying from a reputational point of view, it might be better. I don't actually care one way or the other about that, because I don't really think the reputation of a paper or a broadcaster is based on the level of scienter that applies to its work. I just don't think people think that way. But if you were trying to do it logically, that would be a possible consequence. Sorry, I'm droning on. I don't mean to. Eugene, you're on mute.
I think thought I was about to sneeze, and I wanted to. So I think we're over our hour, in part because it's been such a fun conversation. But I think at this point, probably it's best to leave it at that. And thank you very much, David, for coming on and for submitting the article and publishing the article, which will be real soon now. Thanks very much, Ronell and Greg and Dale for joining us, and for the other listeners, and both those who commented and those who didn't. So very much appreciated. Best wishes to everyone for a happy new year, and looking forward to seeing all of you online in the pages of the journal and elsewhere. So thank you
all so much.